Welcome to Whatsoever More or Less. My name is Jason, and I have a thought for you today on textualism versus originalism. And a little bit maybe on Frederick Douglass, John Taylor, just the prophets in general, the Constitution, what have you. I mean, the Scriptures, Doctrine and Covenants. So, if you look at a lot of what Jefferson and Madison said, for example, they said the Constitution can only mean what it meant when it gained legal force, something to that effect. Now that's, interesting because as a general rule, they're talking about then the text says this, the text says that. However, there was this kind of traditional nervousness that was going around at the time of the founders, since it was, I think I'm saying this right, since it was such a hard thing to get all the states on board because they felt like the federal government would completely take over the states, that a lot of people felt that even where it was clarified or where it wasn't clarified who such and such restrictions applied to, they believed that restriction only applied to the federal government. They felt like restricting the states wasn't okay. There seems to have been a mixed bag out there. Barron v. Baltimore decided to not even hear the case because John Marshall said the Fifth Amendment is strictly a restriction on the federal government. It is not a restriction on the states. But the case was brought like a serious case because clearly there were significant lawyers out there and dissenting Supreme Court justices out there saying, yeah, but this is what the text of the Constitution says. I don't care what you think the understanding under which it was ratified was. This is what the text literally says. And Jefferson and Madison would have been cautious about infringing on the rights of states, yet at the same time, they would have said that the Constitution should be understandable to the average man, that it shouldn't get so confusing, so full of all this. You have to research the history behind this, the history behind that, the history behind this, before you can understand it, but that it should be understandable to the common man, right? So, reading the Fifth Amendment like that, which was ratified separately, it's not like it was all one big package. Each amendment went through its own Article 5 process, so you can't say that the opening phrase of the First Amendment applies to the Fifth Amendment. That's just not true. It can't be true. It doesn't make sense. But why do them all separately, right? Why not treat them as a package deal then, if that's the way you want it to be? So anyhow, I think it's interesting. I'm going to bring up another case here because clearly there were people in the founding generation who disagreed with John Marshall's rejection of the Barron v. Baltimore case. But then there was the people who thought the way John Marshall thought. No, these are only restrictions on the federal government, even though it didn't clearly say it, right? And also, I'll bring up another example here. Federalist 78, written by Hamilton, makes the claim that the opening phrase in Article 3, Section 2, Clause 1 means that basically any case that comes up where anything about the Constitution is challenged, or the laws or the treaties, is the prerogative of the judiciary branch, which ultimately comes down to, by appellate jurisdiction, the Supreme Court, wherever, unless there's exceptions made by Congress. But that doesn't make sense. The same way that Madison said the analysis of Article 1, Section 8, it doesn't make sense to look at that first clause or that last clause as all-encompassing whatever you want to do for the legislature, when there's a clear enumeration in between. And the same thing with Article 3. It was a specific list of types of cases over which the federal judiciary would have power, right? So Jefferson, when he heard Hamilton's opinion that the judicial branch could decide all constitutional questions whatsoever for the rest of us, and this was years and years later, he's like, oh my gosh, that's a terrible doctrine. That would make the complete make us be under a judicial oligarchy, a tyranny. At one point, he referred to it as a criminal suicide pact, basically. So clearly, originalism, where you're trying to find that, okay, this founder said that, this founder said that, this founder said that. I don't see any value in it. I don't see any value in it, because you're always going to be finding somebody who said something, right? There's going to be subtle differences in the first 5 presidents. You know, which one of those presidents would have responded to mobs in one way versus which one of those presidents would have responded to them in another way? Which one of them would have gone for the middle ground of authoritatively negotiating versus which one would have said, I can do nothing for you, versus which one of them would have just gone in there and dealt with it? So what is the traditional, original tradition? I don't know, but when I read the Book of Mormon, traditions of their fathers, that can actually be a bad thing. So I lean towards, there's one way to read the Constitution. I think it's what Frederick Douglass did. First off, he thought about the Declaration of Independence and the natural rights that we believed in as this nation was in its early founding stages. And second off, and I think I'm saying this right, that we read the text of the Constitution in its plain meaning that would have been understandable with the plain definitions of the words to your average person back then. Treaty is one I always come back to. What did they expect a treaty was allowed to do back then, right? That's all the more a treaty can do, okay? But other than that, words have plain meanings. They mean things. And they had plain meanings back then. You can bring up an old dictionary if you question it, a dictionary from the 1700s, if you think maybe something changed in meaning. But other than that, you have to stick to the text, and the default position being a presumption of liberty, or the right to life, liberty, and property, where no harm is being done. And so I think this is the way Douglass understood the Constitution. Now, when we look at the doctrine of the Church of Jesus Christ of Latter-day Saints, we say whatsoever more or less comes of evil. It's a written Constitution. Our loyalty is to the written Constitution. Down A shows clarified 2 different points in defending our divinely inspired Constitution. First off, that it's a written Constitution, and second off, that our loyalty is to it and not to any office holders. And this is God. What is it? John Taylor said, whether the founders knew it or not, God was working through them to make the document he wanted. And so whether they knew it or not, he was getting it done. And I think we can, when you read it like that, you'll come to a conclusion similar to what Frederick Douglass came to, that it is a glorious liberty document, especially when it's accompanied with the understanding of the Declaration of Independence. Follow the text. Don't follow the traditions, because the traditions got messed up right from the start. And that's the problem with originalism. Somebody's always going to be looking for the traditions of the fathers. So originalism is, I've heard some stuff where some Hawaiian Supreme Court justices said, we went back 800 years in traditional law. 800 years, the United States hasn't been around, the Constitution hasn't been around for 800 years. That's a terrible idea. The United States became what we are because we broke away from the traditional tyranny of past governments. So my thoughts on originalism. Originalism is the Declaration of Independence and the meaning of the Constitution, under which it was the dictionary's definitions of each of the words within the Constitution, perhaps legal dictionaries at the time, the Giles Jacobs or something like that. And there you have it. So despite, I think, the first 5 presidents were amazing, every last one of them you can find something that was off with their traditions. And so you have to follow the text. You have to assume the founders didn't know everything they were doing, because John Taylor said they didn't know everything they were doing. You have to assume that whatsoever more or less comes of evil, and tradition is not a valid way of interpreting a legal document. Only straight up official dictionary meanings. And other than that, that's it. So, by the way, a little note on Frederick Douglass. From what I understand, his defense of the Civil War was the preserved liberty aspect in the preamble. And that's probably one of the best defenses I've heard yet. I've heard other people make the privileges and immunities defense. I don't buy it. I don't believe you can lock people into a contract for privileges and immunities of neighboring states. No, I completely disagree. I agree with that about as much as I agree with the HOA or something like that. No. But he might have been onto something there. That's an interesting one. So I need to study him more. I have made some mistakes. I think I said that Frederick Douglass was a congressman. He never was. He was a U.S. Marshal. I know that there were black congressmen before the Civil War. So I think that's where I got confused. But anyhow, read the text. Read the text again and again and again. Modern law schools make you study jurisprudence, as they call it, or the stare decisis, or Supreme Court precedent, whatever. That's not the Constitution, never has been, never will be. Yeah, that's my thoughts regarding that. The actual Constitution can only be changed through the Article 5 process, and that's it. All right, thanks for listening, guys. See ya.